There are a lot of new laws that were passed in Florida in 2023, and several are going to affect family law. Paternity, alimony, time-sharing, and child abuse statutes have all been updated. Here are 4 of the biggest changes to family law that Floridians need to be aware of, because even if they don't affect you directly, they're likely going to affect somebody that you know. The first big change to Florida family law has to do with paternity. Legally, paternity is only an issue when the parents of a child are not married, so baby mama or baby daddy drama. If the mother of the child is married, her husband is the legal father and what's called the natural guardian of the child. And yeah, that's the case even if the husband is not the biological father. The natural guardian of a child automatically has parental rights. But if the parents are not married, right now, only the mother of the child becomes the natural guardian. With the new laws and under the new changes, signing the birth certificate for a dad makes the man a legal father and a natural guardian. So automatically, that's going to come with parental right. It doesn't give him all of the time sharing and parental responsibilities. But if the parties are not together and the parents need to establish a schedule, they're still going to have to go to court, but now they are both guardians of these children. And that's a really big change because as we have it now, only a mom is a natural guardian. So we're now talking about having mom and dad being natural guardians of their children. The next big change that has come into play in Florida family law deals with alimony. The biggest thing is that there's no longer permanent alimony. Permanent alimony is where one spouse has to pay the other one alimony until that person dies or gets remarried. Now, all alimony is going to be calculated based on how long you've been married. At most, if you had what's called a long-term marriage, the longest that you can receive alimony for or that you pay alimony for is 75% of the length of your marriage. Oh, and the definition of a long-term marriage has also changed. It used to be a long-term marriage was 17 years. Now it's 20. So under the new law, if you're married for 20 years, the most that you would have to pay in alimony is 75% of that marriage. So 15 years. That's how long you'd be able to receive alimony for as well. Another big change that we've seen in Florida family law is specific to modifying the time-sharing schedule. So when a couple splits up, they have a time-sharing schedule that's filed in court, a parenting plan, but maybe one parent wants to change it. You may have heard of time-sharing schedules referred to as visitation schedules or custody arrangement or anything like that. What we're talking about is how many nights they spend with mom, how many nights they spend with dad. Under the old law, if one parent wanted to change that schedule, there was a specific legal standard that had to be met, an unforeseen, substantial, and permanent change in the parent situation. This would often be maybe somebody used to work nights and now they work days, or anything that is big and unforeseen. Now, under the new law, the unforeseen language has been completely removed. That means it will likely be easier for modifications to happen. The last big change we've seen in Florida family law, it's a little bit of a controversial subject. We're not going to comment on the law. We're just letting you know what's changed, and that is what's considered child abuse. What's referred to as gender affirming care, which includes things like hormone blockers and gender altering surgeries, has now been banned under the new Florida law. One important detail is that even if a parent takes their child out of state to receive that treatment, if they're Florida residents, they can be charged with child abuse. Realistically, the biggest impact this is going to have in family law is when 2 parents are not on the same page about the care for their child. If couples are united in their beliefs, they can potentially relocate the child to another state. But if they're not together and they're not in agreement, this can become a major issue and grounds for changing parental responsibility and time-sharing schedules. One thing we always stress is that family law is very much a state-by-state issue. With all of the people that have been moving into Florida in the last few years, it's really important to understand that not only are the laws in Florida possibly different in some big ways, but they're also changing. I'm Vanessa Vasquez, founder of the Vasquez de Lara Law Group, and if you want to stay up to date on how family laws in Florida work and how they affect you and your loved ones, make sure to like, follow, and subscribe.